All righty. See, got about 9 people in so far. We're gonna give it a few minutes and let people keep logging in. Um, while you guys are logging in, though, to kind of fill some time, if you guys want to drop in the chat where you're calling in from, we'd love to hear where you're all from. If you want to include any other info, your name, job, favorite pet's name, etc., let us hear it. Oregon, Washington, D.C. Nice, you're close to me. Gio Bella's from Chicago. Nice. I bet weather's beautiful up there right now. Philadelphia, Washington, D.C., San Fran. Okay, we're going coast to coast. Scottsdale. Can't imagine the heat you're feeling right now. Atlanta, another Philly. Awesome.
We got one from Scottsdale too.
I see that.
I think I know Matt actually.
Oh, wait, putting you on the spot, Matt. Couple Philly people. We hope to see you in September. We're coming y'all's way. Denver, Oklahoma, Texas. Nice. New York. Man, I'm loving this. We've gotten people from all over.
Yep, there we go. Put Matt on the spot. That's too funny. Matt's a good guy.
Well, thanks for joining us, Matt. Excited to hear more about you.
Oh, Scottsdale's a small town, so
Haven't been. We did propose it for our SKO for next year, so maybe we'll be out your way, Jared.
that'll be good. That'd be fun.
Awesome. Registration logins are starting to slow down, so I'm going to go through a few housekeeping things. A lot of you guys have figured out the chat already, so please feel free to use that throughout the course of the webinar. We like to be interactive. The session is meant to be engaging. We want you guys to ask questions to Eric, to Jared, to myself. I'm happy to moderate those. We do have a designated QA section at the end, but you don't have to hold your questions till there. We will work those in as we can. We also have a QA box that is live. If you want to ask in the more formal way, that also gets grabbed in our chat and recording, which will be sent out at the end of the webinar, probably tomorrow, if I'm being honest. So we'll share those with you guys. And yeah, let me get my screen shared and we will kick it off. So welcome everybody. Thank you for joining us. Today we're gonna go through how to learn how to build better discovery workflows from pre-litigation to trial. We've got a great timeline set up for you guys. We've got incredible speakers, so I'm very, very excited about this and what we have to introduce you guys to. So without further ado, it sounds like some of you guys already know Jared and Eric. But Jared is the founder of and CEO of Arctrieval, and Eric is the founder and executive chairman of Proof. So I'm going to let Jared introduce himself and talk a little bit about Arctrieval.
Thanks, Taylor. So real quick about Arctreaval and where we got started. So Arctreaval started as a technology platform and software for in-house record custodians and copy services at hospitals and doctors' offices, really throughout the Southwest United States. So we were actually the ones that we were doing two things. One, providing a platform to manage the process, as well as labor and professional services to actually process the requests for patients, insurance companies, other doctors, and of course, legal professionals. And during that time frame, we processed hundreds of thousands of requests for medical and billing records. And it was kind of interesting is originally we were looking to provide this software as a platform for healthcare providers. But if anybody knows anything about healthcare, it operates at 3 speeds: slow, stop, and reverse. And during that time, attorneys kept telling us, hey, you guys are fast, friendly, efficient, and the costs were reasonable. Can you help me get records from other places and other providers? And so in the summer of 2019, we flipped our entire business model from focusing on really healthcare providers and solutions for the medical records department, and took that knowledge and information and built what Arctreaval is today. And it's a new software application that's a productivity tool that slashes the time, effort, and expense it takes to get medical and billing records. And today we'll just talk a little bit about some of the methodologies, backgrounds, and foundations key to Arctreaval's success in terms of just overall technology and what process do you use and how it can help you, not so much the software, but the process itself. So thanks for having me here, and we're looking forward to sharing what our insights with the folks on the line today.
Thanks, Jared. That's awesome. I hadn't heard your founding story before. Welcome, everybody. Thank you, Taylor, for setting this My name is Eric Vode. I am and have been a longtime litigator. Managed a law firm in Denver, Colorado for about 15 years before starting Proof. And a couple, one real general concern of mine and one specific concern of mine really caused me to start Proof about 7 years ago. One is just the expense of litigation, right? We are in an inefficient group that hasn't applied enough technology to the litigation process, and the result is that about 80% of Americans and American businesses can't afford to get inside the courthouse doors, and that really led me to start a legal technology company that is Proof. And specifically, man, did I was driven nuts by how inefficient the service of process industry was. And that was our specific focus 7 years ago. We now, this is hard for me to believe, we serve about 50,000 summons and subpoenas and complaints and third-party garnishments every single month for about 20,000 law firms across our amazing country. Um, and I'm just delighted to be here with Jared to talk about the pain that is, initiating your case and discovery, and some of the tools that we have at our disposal now as lawyers and paralegals to help make those processes more efficient. So maybe we just jump in, Taylor, with the next slide. All right. So I talked a little bit about why we're teaming up here. And the next slide, Taylor, is really us as lawyers and paralegals and just humans, we think in timelines, right? And the best way to kick this webinar out, I believe, and why we put this in here is to provide a timeline. We all should be thinking about our cases in timelines. The rules of civil procedure provide really the timeline through which we're all governed, and then thinking factually through the discovery process in a timeline form makes a lot of sense. So the first thing we're going to talk about, I'll kick it off with, how do you initiate your case and some of the things that Proof can help you with there. Then we're going to go to medical record retrieval with Jared. And then I'm going to talk about written discovery, which is also painful, and some of the great deposition technology that we're seeing out there. So I'll start off here with, what Proof can help you with service of process. And this is the whole reason we started this company. Unbelievably, the federal rules of civil procedure and the state rules of procedure, if you can go to the step one, starting the case, give you 90 days, right? Colorado gives you 90 days to serve the summons and complaint on your defendants. That should tell you everything you need to know about the inefficiency of service of process. And I think the best way to understand how we can help you with that at Proof, or if you choose another tech-enabled process server, is to understand really the way we did it if you aren't using Proof, and the way Proof does it today. And so the first thing is the way we did it before. If I had a case, I just finished drafting the complaint and the summons for all the defendants, say there were 6 defendants, we've got to go find process serving companies where each of those defendants reside or work, right? That takes phone calls and emails, and it drops off this cliff where you've got no real-time information. You've got to call them, you've got to email them to find out where they are with your critical deliveries, right? And then you got to wait days for the affidavit finally. And it's no wonder the court gives you that much time. And the way we've changed it at Proof is we just allow you to upload the documents directly to our web app or through your case management software. We're integrated with a number of them, AI reads those documents, pulls out the defendant's names, the addresses, the rules for service based on the jurisdiction where those documents are filed, finds the process server in our hypothetical closest to each one of those defendants on our mobile app. They pick it up, geolocate the nearest FedEx through some integrated technologies, and then you're tracking them in real time with geolocations, timestamps, photographs, real-time chat right from your phone to the process server and to Proof. The guys down the street at the soccer fields, go serve them. Go serve them there. The address is bad. It just finds the process server closest to the next address, and that process continues. You're almost watching the affidavit get built in real time by the server's attempts at service, communicating without emails and phone calls. And what that gets you is really gets you tremendous efficiency. You eliminate all those phone calls and then emails. It gets you speed. We're delivering these documents. Court's giving you 90 days. We're delivering these documents on average just over 3 across those 50,000 serves every single month. And it gets you transparency. And what transparency does, besides efficiency, it keeps everybody in line. One of my most difficult days as a lawyer was when one of our defendants challenged service of process. We had to do a whole trial just on whether we had done that correctly, and the judge said, "There's no proof," hence our name, and our transparency eliminates that from the equation. So that's really what we do primarily. We've added e-filing to that, so now we can initiate the case in its entirety for you in the same transparent file, serve, file, the affidavits of service process. So that is Proof in a nutshell, how we can help you start the case. We do the same thing for subpoena delivery. And so now, Jared, I'm going to turn it over to you to talk a little bit about medical record retrieval. And what I want to say to the group, I'd love to do a poll. I don't know if we can. What is more painful? Herding cats that are process servers, or what Jared does, medical record retrieval? I think it's a
Yeah,
pretty close,
I'm
a
not
pretty
sure.
close tie.
Yeah, I think both of those are painful processes that we're talking about here, and it's really about improving the efficiencies. And so one of the things that we've seen, and this information is across over 3,000 firms that we've talked to, is really how long are you waiting to get information back? How long are you waiting to get the records that you need, medical and billing, specifically for plaintiff litigation cases? And what we found is over 75% of the firms are waiting more than 3 months for one or more sets of medical or billing records, and over 50% are waiting more than 4 months. And all this is doing is stalling out your client's claim or case, because you're constantly in this battle of following up, chasing providers, chasing requests. So this delay just delays the ultimate settlement and getting justice for your client and making their lives whole again. So the question is how do you fix this particular problem? Most people and there is a way to fix it, is most firms are using what's called a third-party HIPAA authorization. If we go to the next slide, please, Taylor. And there's 2 paths. And what we propose, and if nothing else out of, at least from our point of the presentation today, is we want to convince people to use the individual right of access. It's also part of HIPAA and part of the HIPAA privacy rule, but it's going to eliminate those delays that you're faced with. And let's walk through a couple of examples here. So third-party HIPAA authorization. For example, Eric's my client. He's been injured. He was seen at Good Samaritan Hospital. He'll fill out a third-party HIPAA authorization and say, I give Jared permission to go get a copy of my records. I'll take that. I'll put a cover letter on it and say, Dear Good Samaritan Hospital, we'd please like a copy of Eric's medical records and billing records from these dates of service. Please send it to us. Well, what happens is that drops into a black hole. It's a permission slip. There's no teeth to it. It seems you're always stuck in the processing queue, and staff has to chase this down and follow it up. And there's no real recourse or enforcement of those records. Most state statutes that we run into when it comes to a third-party HIPAA authorization are permissive. For example, here in Arizona, providers may release the information. There's no requirement to do that. Florida may release the information. California may release the information. There's no teeth to it. So you really can't go and complain to anybody and say, hey, this provider's not giving me these records. The other part about this is even if there are some states that say you have to do this within a specific time frame, the providers will still ignore it simply because they know you're not going to go to those steps to enforce the local revised codes or state statutes to get those in the time frame. And here's how it plays out. Oh, I didn't get these records in 30 days. It's been 3 months. Great. You go in front of a judge and say, dear judge, Good Samaritan Hospital didn't give me these records. It took them 4 months to do it. Well, do you have them now? Yeah. Well, what are you complaining about? I got more important things to deal with. So there's really no enforcement action of that. On the other side of the house, which we strongly recommend, and it's also the foundation for our retrieval software and methodology, but it doesn't have to be used with the software. It's just a better way of requesting records. It's the individual right of access. And what it is it enforces and leverages the individual's rights under the HIPAA privacy rule, specifically section 45 CFR 164.524 that says, I have a right to this information. It's a directive. The formulation of these requests is much different. It's not a permission slip. It's we will formulate the request that says now Eric would go and say, dear Good Samaritan Hospital, I am directing you to send an electronic copy of my records to Jared. And oh, by the way, they got to do that in 30 days. They're compelled to do that in 30 days. If they don't do that in 30 days, they're now subject to enforcement actions by the Office for Civil Rights. And this is not a paper entity, tiger entity. For example, back in February of 2022, they fined Banner Health here in Arizona $200,000 for not responding to 2 individual right of access requests within the prescribed 30-day time frame. So, and they also put them on a 2-year corrective action plan where they had to report back to the Office for Civil Rights that they were now in compliance of this agreement they reached as a settlement for not providing the records in the time frame. So it's a much more effective way of getting the records. We advocate everybody, even if you're not going to use our retrieval software, we got folks that do it, but use the individual right of access. It gives you the team and staff the leverage. The providers do have 30 days in which to respond, but if they don't, the conversations with the providers are much different. It's not, hey, what's the status of my records? It's a call to a supervisor saying, hey, you've potentially violated my client's rights. There's a HIPAA violation. And that phrase is like it's a trigger phrase. It's like a glitter bomb going off in the medical records department saying, oh my God, HIPAA violation. Somebody's going to get fired. Somebody's going to get in trouble. No, it's going to get the attention that request needs so you can get the records and you can advance your client's claim or case. Let's go ahead and go to the next slide, please, Taylor. And so then the question becomes, and then a lot of what we were talking about just then is discovery, is pre-litigation. A lot of the personal injury cases or most plaintiff litigation cases never go to trial. It's only a small percentage, but when you do go to trial, how do you get those records? How do you enforce people to actually adhere to a subpoena? A lot of times subpoenas can often be ignored. How do we know this? Well, we were on that other side for a long time, providing the information in response to subpoenas and HIPAA authorizations and other demands. We never were late about it, but we heard horror stories from other folks. One of the quickest ways to get there is we always offer this tip. If you have to subpoena somebody, subpoena the records from somebody, don't just do the hospital and the records department. That guarantees it might get lost. Instead, include the CEO, the CFO, the chief medical officer, the chief operations officer, the president, some executive level, to get them to pay attention. Why? Is because they don't want to go to the deposition. They don't want to bring the records. That will guarantee that that subpoena is going to get into that medical records department, and they're going to say, get this done because I am not going to appear for this deposition. So the idea is to leverage that when necessary. It's a little tip we tell everybody on how to get medical and billing records when you're in litigation and you're in the official discovery process and you're using subpoenas to get that information. Subpoena not just the hospital, but folks at the hospital. Do you want to take it from here, Eric, and discuss more?
Yeah,
more about
absolutely. I love that tip. I really love that tip. Get the CEO involved.
Exactly.
That subpoena is going to land, and you're going to get your documents a lot sooner. Gosh, if I would have known some of the stuff that you provide, Jared, back when I was practicing, I think things would have been a lot easier.
You might still be practicing. Who knows?
Well, I don't know. I don't know about that. But so next subject, next thing in the timeline is something I'm very familiar with. Answering the tedious discovery requests, whether those are interrogatories, document requests, requests for admissions. Man, those were just tedious work. You know, the way I did it always was not a very efficient way. You got to call opposing counsel, which I never wanted to do anyways. Ask them to send you the request in a Word form, so you didn't have to copy and paste or retype all the questions. Then you got to get your client's help through email. Maybe they're coming into the office. You got to get your client to certify the requests. It was You got to go through the objections. You got to dig out other objections you've done in other time periods, review all the discovery documents. I wanted to highlight a tool provided by Esquire Tech. There's other companies that do this as well, but Esquire Tech is one that I'm familiar with. They really have two tools. One's called Alpha, and the other is called Omega. Alpha is what they came out with first. It uses AI to review those requests, create a response shell. Then it provides you one-click jurisdiction appropriate objections. So if you're going to object attorney-client privilege, you just click on attorney-client privilege. Overly burdensome, you just click on that one. There's no cutting and pasting, it just inserts it automatically. You can communicate directly to your client via a mobile app and get them to add color to your responses, or to sign the certification where they are. We know our clients, our individual clients, are on their phones, and collaborating with them where they are is very important. And this technology allows you to do that. Now they've come out with this thing called Omega, which is leveraging AI to evaluate all the discovery documents and draft responses to the interrogatories or document requests from what you've uploaded, from AI's review of what you've uploaded. And then they will QA that, Esquire Tech, and you can as well. But it gets you started. It can save a ton of time, because you don't want to go out there and provide an answer to an interrogatory for your client that is contradictory to the documents in the case. That's just going to get them eaten up at deposition. And it's tough in some of these bigger cases to review all those documents. So use AI to get you a head start. Esquire Tech has got a couple good products that are worth looking into. Next slide. This is where it all happens, right? Depositions, most important part of every case, right? I tell my clients always, you got to pay attention here, because juries actually believe your deposition testimony more than they believe your trial testimony. So it's a very important part of your case, and it's hugely expensive. Many cases don't continue on to trial because of the expense of depositions, both from how hard it is to prepare for them, to how expensive it is, how much money you pay to your deposition provider, and then post deposition. And there are some technologies that are really helping us as lawyers and paralegals in the deposition phase of the case. I've listed some here at the bottom. Scribe and Remote Legal have some great technology that I'm going to talk about. And Filevine has what they call Depo Copilot, which is also very impactful to me. A very, really some fantastic technology for taking a deposition. So, first of all, everybody now, I'm a little bit, um, I've been around for a while, but scheduling, right? These companies have the slick ways to schedule your deposition. There's not a bunch of phone calls and emails. You can really coordinate it with opposing counsel and get it set up pretty easy. One thing that drove me nuts forever when I was practicing is I get all the banker boxes of all the documents to prepare for a deposition. I'm going through them, trying to figure out what exhibits I'm going to bring, and then you're going to make 6 copies of each exhibit that you're going to bring, and you got to wheel them all into the conference room. These technologies allow you just to upload them once to their hosting software. Those are kept private until you decide, based on the flow of the deposition, which ones you want to put in front of the witness. Probably the most interesting part of these technologies is that there is not a stenographer. This is done via Zoom or for their own hosting video platform. But there's nobody typing, right? Because AI is now as accurate as a stenographer. Of course, it has to still be reviewed, but it eliminates, and this is something that I'd love to get a little discussion going in the Q&A session about whether your lawyers are comfortable with these types of depositions that don't have a stenographer. And then after you've done the deposition, AI can help you query the deposition, provide summaries. These are things that, man, I wish I had back when I was practicing. So next page, I'll talk a little bit more about these benefits, and then I'll turn it back over to Jared. Again, the stenographer. With the stenographer, with AI being comparable to the stenographer in first draft accuracy, eliminating that from the equation, some of these technologies are offering deposition services for about 40% of the most expensive providers. And for me, as a lawyer that represented not the Fortune 500, this is a very important thing to kind of even the playing field between your maybe more well-heeled adversaries. This Copilot thing that Filevine and I think Scribe has going is extraordinary. When I started practicing, I'd sit second chair at these depositions and I whisper in the partner's ear at the break, or this is the question you should be asking, or if I dared, that is. Now you're sitting there with this Copilot that is telling you, countless times I'd be like, I got the greatest admissions in that deposition. Then 2-3 weeks later, I get the transcript. I realize I didn't really have those admissions closed. Copilot will tell you, hey, you need to go back. You need to go back and finish that line of questioning, or you haven't hit this line of questioning, or you should ask this question based on the documents that AI Copilot has read. Pretty powerful tool. And then post depo, you're writing your motion for summary judgment, your motion for limine. You just can cut and paste. You can query the transcript, query the video, cut and paste snippets of video for your trial or embed them into your demand letter or embed them into your motion. We all know video is more powerful than a page of text. If the judge or opposing counsel or an insurance company can see that video and the reaction of the witness to that killer exhibit that you just put in front of them, that is very powerful to add to your brief or to your motion. So those are some of the benefits. I really love where some of these companies are taking depositions. So I'm going to flip it back to you on that note, Jared, to kind of, maybe we both can kind of sum up some of the advantages of these technology-enabled workflows on the next slide.
Yeah, I'm gonna chime in there real quick. We got a question in the QA, Eric, asking about California requiring a stenographer. How do you advise handling optimizations where there are states that still require the stenographer.
Yeah, so you got to read the rules, as our law professors all taught us. You start with the rule. Most states now allow expressly in their rules of civil procedure for non-stenographic depositions. In California, and I'm not aware of the details, I think it's likely that you can agree with opposing counsel on a way to take the deposition that doesn't include a stenographer, and also agree to its admissibility at trial. So you can always take that route. I will, if I can get your email, I can ask the folks I know at Scribe and Remote Depot for their answer to that question. I'd love to get that to you.
Awesome.
All right,
So
Jared, you want to talk a little bit about how?
sure. So
Yeah.
I think we want to frame this correctly. So a lot of times when you're looking at getting information to support your client's claim or case, and whether it's subpoenas or requests or there's other things that you have to do, a lot of it is people try and throw roadblocks up in your way. And in the medical records field, it's about not getting the information back to you. In subpoenas, it's making sure you have the correct location and address and who you're trying to get the records from and who's ultimately responsible for furnishing it. And when you look at that and you see people are trying to prevent you to advance your claim or case, technology is a productivity tool that can really help you with those outcomes. It's about accuracy and automation to reduce the amount of effort and friction in the overall process. And that's really critical. For example, when it comes to the release of information from medical and billing records, the hospitals and providers are risk adverse. Their process is to filter out requests, find reasons why they don't have to or they shouldn't provide the information to you. So when you look at these productivity tools and you're looking at technology, you should always ask yourself, well, is this going to save me time? What's the benefit I'm going to get out of this? Is there efficiencies to be gained? And it's a lot of these manual repetitive tasks. So for example, and I have to draw heavily, obviously, on the medical record and billing request process, even though we have technology supported tools that will create that form letter, you still got to get it to the people. You still got to attach it to an email, attach it to a fax, put it on the fax server, get it out, hope it gets there, and then you got to do the follow-up. It's not much different when you're also, and Eric was talking about this, when you're serving subpoenas. How do you get that information back in the field? What's going on? What is the process? How do you use automation to make sure that what's happening is what you need to have happen? And so even though we have these tools and we have word processing, we can create it, there's still a lot of manual inefficient processes. So you want to look at workflow productivity tools that say, yes, I can solve that. Now, one of the things that I always like to tell our clients and anybody else about technology is there is not going to be a silver bullet perfect solution for all cases in all situations. Everybody will say, oh, and it doesn't matter what platforms. Oh, I hate this case management system. I like that case management system. I don't like this. I like that. Whatever it happens to be, does it improve the workflow? Does it eliminate 80, 90% of the friction in the process? Can you live without that last 10 to 15% or 20%? Because there's always going to be human interaction and involvement in these things because there's no perfect way to get everything. So you want to look at things that can they improve your office inefficiency. For example, in the case of Arctreaval, how do we eliminate 80% of the phone call the staff makes? If you ask your staff, hey, do you like calling medical providers? No, they all hate it. Why? Because it's a runaround. It's a huge waste of time. How do you eliminate that process? How do you get providers to respond in 30 days? How do you make sure your subpoena is heard and gets to the right person so that information comes back so you're not waiting months and months and months? Again, that's the promise that technology brings. And in some cases, the legal field has been a little late to adopt some of these, but now we're rushing head on into a lot of things as well. I would also urge a word of caution. Just because it has a fancy buzzword attached to it doesn't necessarily mean it's going to do what you need it to. And you also have to, in some cases, be willing to make a intellectual investment into the tools that you're using. It's not just going to switch on. There are a lot of powerful tools, but you have to learn how to use them well as long as the way. And the biggest thing what you want to do when you're looking at whether it's Arctreaval, Proof, Esquire Tech, Copilot, Filevine, MyCase, Neos, any of the case management systems out there, is how does this technology, how am I going to be able to leverage this technology to eliminate some manual or labor-intensive process as I use it to advance my claim or case forward, whether it is personal injury or plaintiff litigation, or perhaps something in business law, not my area of expertise, but these tools are out there if they're used effectively. And that's really the focus of what we want to talk about here, is what some of those tools were out there when it comes to specifically, how do I get that information to support my client's claim or case and advance that and get a settlement and get resolution in the quickest method possible with an optimized outcome. So
Jared, I love that. And I keep looking at the middle, green or yellow rectangle here, minimize burnout from repetitive manual tasks. Do this for yourselves. The best things about practicing law or being a paralegal are not these repetitive tasks. Do this for your clients, because if you're more efficient, you're going to be able to take more cases. There's a whole bunch of cases that you don't even have to compete for if you're more efficient. This has been fantastic. I think it's time, Taylor. Is it time for questions and answers?
It absolutely is. And we already have one that's come in, Jared, that I'll direct to you towards you. A user has been having issues with the individual right of access, and that the providers are going straight to the clients and bypassing them as their legal team, even though they've been guided not to. So they said it's become burdensome to their clients. Have you seen the same thing, and what would be your solution to get the providers to engage with them?
Well, the individual right of access request, and it's tied into high tech, which there's a lot of misunderstanding about. And let me frame it, and then I'll answer the question. So what we have is individual right of access request under section 164.524 dictates, it says, I, the individual, or my personal representative as defined by HIPAA, has a right to this information. I have a right to get a copy of that information sent to me and have it sent to me. So that's part one. That's the general premise of HIPAA. And there are some things happening to modify the HIPAA privacy rule. And that was back in 2009 when that first came out. And then Congress kind of reviewed that in 2013 and said, okay, there's some deficiencies here because I'm requesting records. I want them electronic as the individual, but the provider's sending me stacks of paper and charging me stupid amounts of money. And so what they said is they introduced this into the High Tech Act, and this is where the confusion comes from, is the High Tech Act extends let's say the leverage that you get from that original rule. It has three major components to it. First is I, the individual, if I request records and I want them coming to me, I can specify they come in an electronic format. They have to deliver that to me in an electronic format. Also, per the High Tech Act, I have the ability to direct that electronic copy to any designated third party I choose. So I could say, I want you, Good Samaritan Hospital, to send these electronic records to my doctor, to my insurance company, to my employer, to my wife, to my attorney, to Taco Bell down the street. Doesn't matter, they got to do it. So that's the framework that they have to work within. The next piece was cost, and this is where a lot of confusion came in, is per the High Tech Act, it says if you send the records to me, there's a cost-based rate for those records, and it was $6.50, and everybody called it a high-tech request, and really there is no such thing as a high-tech request. And what happened is Department of Health and Human Services said, hey, it's effective whether the records are going to the client directly, the individual, or they're going to a third party. It's still the individual or the client requesting their records. You shouldn't be overcharging for records going to a third party. And so they had guidance in an ombudsman's ruling that said, hey, you can't charge more than that. That was struck down in a decision in January of 2020 in Sykes versus Azar, which said, nope, the application of that cost-based rate was not designated in the High Tech Act. Therefore, we're going to take it down, and it's based upon local state rates. So that's the framework. So the individual right of access request, that requirement to still respond within 30 days and respond directly to the designated third party is alive and well. And sometimes you have to kick down doors and make people aware of this. And we've been very effective at that with our client base and the requests. We're issuing 60,000 requests a month right now, and we have very low problems with compliance in general because they're required to do this. It's also how you formulate it. And the reason I gave kind of a little bit more background, if you're seeking that $6.50 cost-based fee for the records, then the records must be delivered to the individual today. If they're delivered to a third party, the state rates for the production of the records is what holds. So a lot of people are saying, oh, they don't work because I can't get that $6.50 rate. You're absolutely correct. That's not going to happen right now. And where it makes sense is if you're dealing with a large case with a large record set, then yeah, it might make sense to inconvenience the client, but not for everything. If it's a typical motor vehicle accident and there's nothing that's typical and the record sets are smaller, then you're going to still have to bear the cost of the records. And unfortunately, legislation in general across most states and on the federal level has not kept up with the advancement of technology. It doesn't take the same amount of work to produce a PDF file of 1,000 pages of records as it would 30 years ago, standing in a file room with a photocopier making a copy of 1,000 pages. So that's where the disconnect comes from. But in general, if they're formulated correctly, and if you contact us, we'll share what our individual right of access request template looks like. It's very effective. They do have to comply with it. And then the question is how do you follow up and how do you make sure they comply? And once you get through that facility once and you get to the right person, if they're being sticky, they have to educate their staff. And it's usually the least paid folks that don't care about stuff and they just say no because it's the least passive resistance for them to get their job done. So
Awesome.
that was a lot at once. Hopefully that's a difference. Somebody else asked us, and I saw that in the questions, how are you different than Chart Squad? I'm going to phrase this, how's Arctreaval different than any record retrieval service? So you're not giving us the records and we're not chasing them down and making the phone calls. We're not charging $50, $60 per pull. What we have is we have a productivity tool. We've taken effectively everything that record retrieval services do, encapsulated it in a software tool, allow it to plug into your case management system, and we let the software do the work. So the software is doing roughly 80 to 90% of what a retrieval service does for 10 to 15% of the cost and taking that follow-up burden off of your staff. That's what Arctreaval does differently.
Regarding the FileVine integrations, both platforms do and are integrated with FileVine. Happy to share some follow-up information on the integrations as well. They're native integrations that are optimized for your workflows. Arctreaval and Proof, we've all done webinars with FileVine directly in the past. So I'll be happy to share those with you guys to get a little bit more information. And then as always, our team is always here to help as well. And then in the chat, Tim is also sharing some information regarding FileVine. And then there was a question regarding pricing for Proof and pricing for Arctreaval. So that has been shared in the chat, and I will also share it and follow up. I am going to keep it going to get a couple more questions before we wrap up.
I see a really good one I'd like to take, Taylor, if that's okay. And it applies a lot to do with information that came in from Alicia. If I may I take that question?
Go for it.
So one of the questions, this is a broad understanding. So this is really, I want to tackle this one. So does the individual right of access does it have to be approved by the client? So it has to be signed by the client, and we have methodologies in Arctreaval to do that in terms of auto signing using it's been in the news, an auto pen type of thing, or a digital image of somebody's signature that can be affixed to an individual right of access. So the clients don't have to be involved. But more importantly, this is the more important piece. Can you get affidavits with an individual right of access request? And I want to back up on this a second. So difference between affidavits and declarations. There is no requirement in the HIPAA privacy rules or on most state levels that sworn affidavits are required. That's number one. Declaration saying, hey, these are true and accurate copy, an unsworn declaration is not often required. Some states do require it, that you have to do it, like Texas does have some requirements. But in general, there's not requirements. Now, with that said, in most cases, most facilities will provide an unsworn declaration attesting to the authenticity of the records. If you want a sworn declaration and need that affidavit, in most cases, you're going to have to issue a subpoena when the case has been filed and part of official discovery. It's part of that process. So there's no requirement when you're just issuing requests and you're trying to get the records from a hospital or doctor's office. They'll usually do the declaration, but affidavits are only required, sworn affidavits are only required with the subpoena in most states. So just be aware of that. You can get them in most cases, and most folks will do it. But if you don't get it, you're going to have to wait till you get to litigation to get that notarized official sworn declaration. I hope that helps with that answer. And that's really nationwide, unless you're in a state that requires it or has a provision for it in their revised statutes like Texas does.
Awesome. Thank you, Jared. There's a few more questions in the chat. I will follow up with you guys following the call so we can keep moving along, because I know we're actually just slightly over time. I did want to invite you guys. Arctreaval is actually having their own webinar tomorrow as well that dives deeper into all things Arctreaval, getting into the pros and cons and different request methods. It's really a hands-on approach that Jared will be leading. I don't know if you want to add anything to that, Jared.
We're gonna dive into the different methodologies of getting records, everywhere from, some people say have your clients get it, talk about subpoenas, when to use that, when a third-party HIPAA authorization may make sense, sending clients in, how to get VA records, and really how to effectively use an individual right of access request. I would say it's 80% educational. We'll do a quick tour of how Arctreaval implements that, but again, we want to delve deeper into how do we solve this problem and eliminate the bottlenecks getting critical information for your client's claim or case in a injury-related matter.
Awesome. Thanks, Jared. And that brings us to time. I want to thank everybody for engaging with us via the Q&A and the chat box. Any questions we didn't get to answer, I will definitely follow up with you guys on that. We hope you guys enjoyed the presentation and found it useful. I will be putting a poll up following the wrap of the call. But if you guys want to reach out to anybody at Arctreaval or Proof, please feel free to email us. We're always happy to hop on a call with you and introduce you to your team. But I also want to take a minute to thank Eric and Jared for their time. These guys are very busy, very knowledgeable. So we appreciate their time and them coming online today and all the preparation that they put into this presentation, and look forward to doing it again with you guys soon. So thank you all. And I will be sharing the recording tomorrow. And if you have any questions, you can respond to that email, reach out to us here. We're always available to you. Thank you all.
Thanks, everybody.
One quick thing, Taylor, is I see one of the folks on our team posted the link to register for our webinar tomorrow. If they'd like that, they can just click on the link and sign up. It's at 1 p.m. Eastern and rolls back obviously into the different time zones that people happen to be in.
Awesome. Thanks, Jared. Thanks, Jessica, for sharing that link.
Thanks, everybody.
All right, see ya. Thank you.